Welcome back to Quick Bits. A lot happened this past week, and I am going to break it down as fast as I can, which is always a feat. We need to talk about a lot of in-court activity, from the Tom Girardi trial, the Young Thug trial, to what's happening in the Karen Reed case after oral arguments on Friday, August 9th. More happening in Kouri Richins, that case out of Utah. And of course, the Rust Armorer case is not done, as the lawyers are still fighting. And yes, prosecutor Kari Morrisey goes off, which is wild after everything that happened in the Baldwin case. And the court had a lot to say in their written ruling in the Baldwin case. So with all of that, we're going to try to make it quick, so let's get into it. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. Starting off with the Rust Armorer case, the prosecutor Kari Morrisey, who was on both cases, remember, she was specially appointed in New Mexico as a special prosecutor. Years ago, I covered the filings where the district attorney's office had asked the legislature for more money to pay for these prosecutions and pay the salary of Kari Morrisey. And the DA has stated that Kari Morrisey is still the attorney handling these cases, and she's handling it with her signature level of snark. What's funny about this is the court's scathing ruling in the Alec Baldwin dismissal came down the same day as Kari Morrisey's deeply snarky response in the Rust Armorer case. The court's motion really laid out how they feel the prosecution and law enforcement in the Baldwin case fell far below the standards that they needed to meet for disclosures of evidence, amongst other things. And Kari Morrisey in her motion wrote that she thinks the judge misunderstood the whole thing when it comes to the Baldwin matter. With regard to the Rust Armorer, the defense is arguing that that case should have a new trial and or be dismissed. And while those motions are pending, that Armorer Hannah Gutierrez should be released from custody. That's the thing that's the least likely to happen in all of this, but we will see. The defense hasn't filed their reply yet, and we are a little ways off from the court holding oral arguments in that matter. But when oral arguments are set, I'll let you know in the Law Nerd app, and we will be covering it. Those will probably be by Zoom. That's what the court has traditionally done in these cases, only having the attorneys in court for trial, everything else being handled remotely. So we will see what happens, but the court's not happy. And I think this level of snark from the prosecution saying that the court misunderstood the situation and that really it's not that bad is not going to be well taken by Judge Summer. And it's interesting to see that essentially nothing has been learned from what happened in the Baldwin case, but maybe that's because the prosecution very candidly said in their motion that they still don't understand what the court is so upset about with those rounds that were turned over to Santa Fe sheriffs. The prosecution said clearly in their motion, this is not a big deal. Well, the court and the law disagree, and those motions are moving forward. I think the strongest argument in the Hannah Gutierrez motion from the defense, that a recorded interview from Seth Kinney was never turned over to the defense. And it's becoming clearer that perhaps Seth Kinney did have mixed rounds coming back from that set of 1883. And those could have been mixed when they went to Sarah Zachary, which undercuts the prosecution's theory that the only way live rounds got onto set was because Hannah Gutierrez had the mixed rounds from Thel. But it seems that after 1883, some of Thel's rounds went to be stored with Troy Teskey, and some of the rounds went to Seth Kinney. So there is quite a lot to be argued there. The prosecution legally, after all of their snark, is arguing that this is all cumulative information. This is not new information, and therefore it's not information that requires a new trial. We'll see what happens. Remember, the standard for a new trial in the situation of Hannah Gutierrez is legally different than the standard for Alec Baldwin, because of the timing of when these things were discovered. It is a different situation mid-trial than it is after trial under the law as it is in New Mexico. I broke all that down on stream if you want to get into the nuts and bolts of all those motions, but the snark, my goodness. And I'll link the quick bits down below where I broke down just that snarky motion so you can see what I'm talking about. And talking about motions to dismiss a case and potential Brady violations, the Young Thug RICO case, now under a new judge, has been having hearings all the week of August 5th, except for Friday, to try to get this case back on track. The jury has been out for over a month now, and part of what's been happening in that time is dealing with these ex-parte hearings regarding witness Kenneth Copeland, who testified after meetings with prosecutors and the judge. The court has ruled that all of that testimony must be stricken and that witness needs to testify again. Though when he came in for questioning during these hearings and asked if he would testify, his response verbatim was, "It depends on how I wake up in the morning." Kenneth Copeland is not thrilled about testifying in this trial, and I can absolutely understand why. But one of the things that has come out from all of these hearings is that prosecutors did not turn over the statement from Kenneth Copeland in those ex parte hearings that he stated, "I lie all the time. I lie about everything," except for this statement. "It's true that I lie about everything." That statement is a huge statement for the defense to use to impeach him when he does testify again. And the judge denied all of the defense motions for mistrial, to recuse the prosecution team, though did have some strong words for prosecutors and ordered them all to go to Brady training. But the court said that the issues can be cured. This trial is expected to go on until at least March of 2025. However, the court also made very clear that in introducing herself to the jury, because the jury is going to be coming back to a brand new judge, and they're not supposed to be watching anything about this case in the time they've not been in session. So in theory, and optimistically, the jury doesn't know about everything that's been happening. The jury shouldn't know there's a new judge. So this judge worked with all the attorneys to determine what would be said to them and to let them know they have to forget and ignore everything that Copeland testified to previously. The court did say she would ask jurors if they could do that. And if jurors indicated they could not put the testimony out of their mind, they couldn't unring that bell, they couldn't put the shit back in the horse, then those jurors would need to be excused, which could land us in a circumstance where there are not enough jurors to move forward. So depending on what happens with Kenneth Copeland and depending on what happens with these jurors on Monday, August 12th, this case might end up in a mistrial because the jurors can't move forward. And even though the court denied all the defense motions, the defense attorneys have said that they are asking for an immediate writ so that the appellate court could take a look, saying that all of the things that have gone before in this case cannot be cured by this judge. And I appreciate the judge trying to move this case forward, trying to rein in some of the wild behavior we've seen in court, and really pushing prosecutors to do the basic tenets of their job, like turning over evidence and, disclosing witness statements to the defense, the bare minimum, really. So the court is very mindful, and the court seems to be amenable to the defense motions, even though these motions were denied. I think if the prosecution is found to not turn over things in the future in this case, we're going to see different rulings, but we'll have to wait and see as this trial again gets underway. Remember, this case has already been in trial, including jury selection, for 18 months. Absolutely wild. From trial in Georgia to trial in federal court in Los Angeles, Tom Girardi, the attorney married to Real Housewives of Beverly Hills, Erica Jane, who was the hero of the downtrodden. And if you can't hear my sarcasm, trust that it is there, because the behavior that has come out since his law firm's collapse in 2020, his subsequent disbarment, lots of legal actions, and the uncovering of over $100 million of liability in the law firm's bankruptcy, and tens of millions of dollars stolen from clients and more to be alleged to be stolen from clients. This trial is finally underway as to 4 specific clients. Are there more that were stolen from? Yes. Is there still a federal prosecution pending in federal court in Illinois? Yes. That comes out of the Lion Air crash, which really was the final straw that toppled this case. If you are interested in Girardi, I have an entire playlist over on the Emily D. Baker channel and an interview with Jay Edelson, the lawyer that really kept pulling the thread that unraveled a lot of this in the course of that Lion Air case. But what's happening in federal court in LA is what we expect from a federal prosecution. First, no video, no audio, no nothing. Second, we're just seeing the AUSAs methodically go through their witnesses. And I will be breaking that down more on the podcast this week. But we've heard from clients of Girardi, and I think really powerful testimony from a lawyer that worked at Girardi Keese that was fighting with Tom to get one of the victims charged here paid. And Tom was fighting back with her. And then she also ended up getting sued by the client who didn't get paid, even though internally she was fighting with Girardi. No matter what the defense tries to throw at this jury about Tom Girardi and potentially getting older and the CFO really being the one who was wrong here, the attorney working with Tom who was being shut down by him trying to get a client paid, I don't think is anything the defense can get around. That attorney knew that what Tom was doing was wrong and ultimately quit the firm over it. But I think that's going to be really difficult testimony for the defense to work their way around. It wasn't the CFO lying about why the client hadn't gotten paid. It was Tom, including lying that the IRS taxed women different than men. And he was working with people at the IRS so that this client wouldn't get taxed woman tax? Yep. That happened in testimony. So I am following along with those that are in the courtroom and the reporting coming out of the courtroom, and I will be updating what each witness talked about a little bit more in the Emily Show podcast this Wednesday. Keeping with the theme of stealing money, Kouri Richins was back in court in Utah, and it has been a minute since we have been back in court in Summit County. Kouri Richins is accused of poisoning her husband in a laced Moscow Mule. If you remember, she is the children's book author who wrote a book about grief after her husband passed away, but before she was arrested and charged with his murder. But after she was Googling luxury prisons for rich people, she is moving towards preliminary hearing in Utah. The prosecution says that hearing will be about 3 days long. Before she left the case, attorney Sky Lazaro had filed a motion to have the entire prosecutor's office removed from the case, or to at least have Brad Bloodworth, yes, his real name, the lead prosecutor, removed from the case. The court very quickly denied that motion. Kouri Richins now has new attorneys. I doubt she's going to be asking these attorneys to try to sneak crushed white strips into the jail for her. Yes, that did previously happen. It's a really interesting case with a very interesting defendant, but the prosecution is alleging that this murder happened because Kouri Richins was so deeply in debt, was also in a relationship with who is only referred to in court filings as her paramour, not the band, and she knew under her prenuptial agreement that if her husband died in the course of their marriage, what was his would be hers. But if they were to divorce, that money would go with her husband and everybody would kind of take what they came in with. And for Kouri Richins, that was a lot of debt. And so the financial crimes also got tacked on. So she is charged with murder and attempted murder, as well as numerous financial crimes, mortgage fraud, and more. The bond and bail hearing in that case was very interesting. It was only a day long, and she has been denied bond. The preliminary hearing, 3 days long, will be very interesting. I hope it's streamed. So far, the court has not allowed streaming out. We've had video after court. I will keep you in the loop about how I'll be covering that. I very much hope we will have streaming access to this preliminary hearing because it's going to be very interesting and it will feel like a no jury present mini trial. I think they could do this preliminary hearing in well less than 3 days, but I think the DA's office is going to show everything they have in this case, and we will go from there. And after a word from today's sponsor, we need to talk about what happened in court on Friday in the Karen Read case. When life gets busy, our sponsor, Factor, has got your back. Sometimes you don't even have time to throw together pre-prepped meals. You just need something that you can either grab and go or heat in like 2 minutes and be ready to roll. Back to school time is definitely busy over at the Baker House, and Factor Meals have made sure that I have lunch on the day that Dr. B does not steal them and take them to work. Factor has 35 different meals and over 60 add-ons, so you can supplement breakfast. If you want to eat Factor for dinner, you can supplement things for lunch on your weekly order. They are restaurant quality meals with premium ingredients that are created with chefs and dietitians, so you can pick from the eating style that works well for you to either meet your health goals, get some extra protein in, or look for vegan meals that are just ready to go. Plus, you don't have to shop, prep, and there's no cleaning up. So if you're ready to give Factor a try for yourself, head to factormeals.com/QBLawnerd50, because it's the quick bits, and use code QBLawnerd50 to get 50% off your first box plus 20% off your next month. That's code QBLawnerd50 at factormeals.com/QBLawnerd50, or the link is right down below, and you get that 50% off your first box, 20% off your next month while your subscription is active. Let's get back to the rest of the quick bits. Friday, we were back in court in Massachusetts for oral argument on Karen Reed's defense attorney's motion to dismiss. And as I suspected, they argued a little bit of a motion to dismiss and a lot bit asking the court to just allow them to inquire of all 12 jurors if the jury did in fact reach unanimous verdicts on counts 1 and 3. Remember, count 2, I broke down on the Emily Show podcast, and I broke that down with all of those lesser included crimes. Counts 1 and 3 are the intentional counts. Count 1 being that second-degree murder, meaning she decided to kill the victim and then did that with her car. Count 3 being that she knew she hit the victim with her car and then chose to leave. Count 2 leaves a lot more room for interpretation of what the defendant knew or didn't know. It also leaves open the possibility of accidentally hitting the victim with her car and not knowing it. So when it comes to the jury stating that they reached verdicts on count 1 and 3 and then got lost in the mix of those lesser included crimes on count 2, it legally makes sense to me how they could come to that result. The court allowed the defense and prosecution to thoroughly make their record on oral arguments, but legally the defense is in the tougher spot on these motions. The prosecution has argued again and again that the law in Massachusetts does not allow for inquiry into the jury decision-making process, to which the defense has responded, but asking them the result of the deliberations is not inquiring into the deliberative process. This all really comes down to whether jurors can be polled in Massachusetts, and will the court allow that to happen after the fact, after a mistrial has been declared. But this is a long way from done. If the court denies the motion outright in its entirety, it's going to get appealed. If the court allows for the inquiry with the jurors, it may get appealed by the prosecution, or they may allow the inquiries with the jurors, and then we will have to see how the attorneys argue to take that information and use it to dismiss those counts, which after a mistrial, I don't know if the court can, and the defense doesn't want to argue a motion for new trial here. That's what they already have. They want a new trial, if any, on only count 2 and the lesser included, not on counts 1 and 3. Again, I personally hope that what the jurors had to say is known. The defense made some good points in their argument that not a single juror has spoken up to say, no, that's not what we decided. So did 12 jurors really reach unanimous and final verdicts on those counts? And if they did, would it violate Karen Reed's double jeopardy constitutional right to try her again on counts 1 and 3? Of course, the district attorney's office could dismiss those counts and choose to just retry her on count 2, but thus far they've indicated they're not going to do so, which is an interesting choice given how many of their investigating officers are under their own investigation. One, the lead investigator, who has been suspended without pay due to his behavior in the Karen Reed case, And last week, Brady Letters went out letting other defense attorneys know of the violations by Trooper Proctor. And let's take a look at that real quick. What we are looking at is a redacted letter that states, "Dear Attorney, this letter is to inform you that pursuant to Massachusetts Rule of Criminal Procedure 14A1A3, the Norfolk District Attorney's Office is aware of information that in the Commonwealth versus Karen Reed," and then it gives a case number, "Massachusetts State Police Trooper Michael Proctor testified and was subject to cross-examination relating to alleged conflicts of interest, communications with non-involved civilian persons regarding the case, and statements regarding the defendant from which defense counsel argued a bias could be found. In addition, this office is aware that Trooper Proctor is currently suspended without pay pending an open internal affairs investigation by Massachusetts State Police. Attached is the unofficial transcript of Trooper Proctor's testimony on June 10th and June 12th. This was compiled using SpeakRight from the court media pool feed obtained from Court TV and Canton Community Television websites and was proofed by this office." So, hey, here's all his testimony. Also, Court TV has it. While best efforts were used to achieve accuracy, this is being provided for discovery purposes of the statements made, but is not an official transcript amenable for impeachment purposes. The official transcript has been ordered to the extent that the testimony references a prior proceeding and text messages from throughout that proceeding pursuant to Mass Rule of Criminal Procedure 14A1E. Such material is subject to a judicially signed federal court order and is not within the control of the Norfolk District Attorney's Office. Requests for information should be made to the United States Attorney's Office. That's talking about the federal investigation. This is the DA's office saying, hey, this is the letter that needs to go out in every case that Trooper Michael Proctor is attached to. And it needs to be known that he has made statements that the defense argues shows bias. You can make your own determination. And this is the testimony. And relating to another investigation, there is another investigation, and you need to go to the feds for information on that investigation. It is going to be very difficult for other prosecutors that have cases with Michael Proctor to move forward without addressing some of these issues. And how they choose to navigate that in upcoming cases will be interesting to see, because we are not done with the fallout from the testimony in the Karen Reed case. And we are a very, very long way from done with the issues here with the Karen Reed jury, because no matter what the court does here, we are at the beginning of a very long process. Remember, the retrial in Karen Reed is scheduled for January 2025. So there is time between now and then for the defense to keep fighting for those counts to be dismissed. We will see what happens. Let me know if the quick bits are helpful for you down below in the comments. I hope that the summaries help keep you in the loop when cases are moving quickly. Thank you for being here. Thank you for being a law nerd. This has been a slightly longer quick bits, but I will see you in the next one. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.